Dr. Scott Jensen here. Today I want to talk about the human side of filing lawsuits against good people. I want to try to unpack what the lawsuits that I am bringing against the Minnesota Board of Medical Practice and against the Attorney General, Keith Ellison, what they've been about. So let's just try to break it down. Let's pretend that these are the two lawsuits. We have the Minnesota Constitution, and then we have the U.S. Constitution. So we have the federal and the state. So these are the two lawsuits that we brought. So this lawsuit came about because of this lawsuit. So what I initially was about was more than a year ago, after 6 investigations and some 20 allegations against me, I had my day in court, pun intended, with the Minnesota Board of Medical Practice. And after a productive 90-minute conversation and recess, the Minnesota Board of Medical Practice reconvened with me and advised me and my attorney that all the allegations had been dismissed. There was no discipline, nothing. It was basically gone. And we were done. Over the next couple of months, I made the decision that there are some problems that need to be addressed, either from a legislative or a judicial perspective. And I filed suit against the Minnesota Board of Medical Practice in federal district court. Or I should say, I made plans to do so. But as one of the first steps to do this, my attorneys filed a Minnesota Data Practices Act request, which is like a state level FOIA, and FOIA is federal, Freedom of Information Act. So the FOIA abbreviation really fits with the federal law, but in Minnesota, it's called the Data Practices Act. And I wanted to know what I was entitled to know about Scott Jensen in regards to conversations the Minnesota Board of Medical Practice had about me and the Attorney General's office, because the Attorney General, by state statute, is the legal counsel and the legal resource for the Minnesota Board of Medical Practice. So it made sense that there might have been conversations back and forth between them as all these investigations were coming down the pike against me. And I thought many of them were unfair. So that was what we're going to do, is we're going to file a suit in the federal district court against the state of Minnesota Board of Medical Practice. That's the way you're supposed to do it in the legal world. What happened was the Minnesota Board of Medical Practice complied with our Data Practices Act, and they sent us the information that we were entitled to see. The Attorney General's office sent us some information as well, but also let us know that they were not going to send everything that we might want, or possibly even not everything we might be entitled to, because they were concerned that some of what they might send me might be incendiary or inflammatory enough that if I talked about it in the public square, it might cause their staff and the people who work in that office to be subjected to harassing phone calls and name calling and things like that. Well, that's not really the Attorney General's office's call. The Attorney General is supposed to uphold the Constitution of Minnesota. So basically, my attorneys and I felt like, well, this is not right. So we filed a separate suit against the Attorney General, and that was in the Minnesota District Court. And that was basically saying that the Attorney General wasn't complying with the Minnesota Constitution. Well, that suit against the Attorney General was settled a couple months ago. Basically, we had received hundreds of pages from the Attorney General's office regarding Scott Jensen. But we had been advised that there was more that they weren't going to send. Probably thousands of pages. So we went to court, the Minnesota District Court. Judge Kane looked the situation over and basically said that much of what the Attorney General's office was withholding from me might well be that which I was entitled to see. So in response to that, the attorneys for the Attorney General's office said, well, a lot of this didn't have anything to do with the Minnesota Board of Medical Practice and Scott Jensen. It might have had something to do with Scott Jensen when I served in the Senate or was involved with a bill, or even when I worked with the Attorney General's office as a senator. Well, we made it clear that we didn't need to see that stuff. We wanted to know about the Board of Medical Practice. And so the judge said, well, we could go a couple different ways here. You guys could try to work it out a little bit, or the judge could appoint someone to run through all these documents, and we'd have to pay them, and we would split the cost, the Attorney General's and Scott Jensen, and it could be in the hundreds of thousands of dollars. Well, that got both of us thinking. We didn't want that. So basically, my attorneys started talking with the Attorney General's attorneys, and we were able to throw out a fair amount of stuff that we didn't need to see, didn't want to see. Then, in the process of the courts, the Attorney General's office did supply us with more information than they had originally, and we appreciated that. But we came down to still some documents that the Attorney General's office did not want to supply us. And so this was a much more finite subset of documents. And so the judge looked at that and said, okay, there's still more here that does need to be delivered to Scott Jensen and his attorneys. So the judge ruled, I think there were 11 documents that they needed to produce for me. And at that point in time, that was the judge's ruling. The Attorney General's office had the right to reject that decision and appeal it, and so did we. We said, the judge looked them over. We'd already gotten additional dozens and dozens of pages. Yeah, we would take those 11 documents and call it a day. The Attorney General's office also looked it over and said, all right, we can live with that. We'll produce the documents. And then they came to my attorneys and said, there's one document that has no pertinence. And my attorneys talked with their attorneys and we threw that one out. So I believe that the Attorney General's office produced the 10 additional documents. I've looked those over, and they did help give us an understanding of what the Minnesota Board of Medical Practice had done. So basically at that point in time, that case was over. We both accepted the decision of the judge. I felt that it was a win for us because the Attorney General's office had indeed been forced to produce documents that they weren't going to. They might have felt that it was a win for them because they didn't have to turn over hundreds of pages that they did not think were pertinent. So that Minnesota District Court case is closed. Now we still have the federal case, the federal district court. And basically we're going to appear in court in August. We've got a scheduled court date before Judge Jerry Blackwell, the Honorable Judge Jerry Blackwell. So that situation is that I am suing the Minnesota Board of Medical Practice for violating my First Amendment rights. We're trying to make the case that the Minnesota Board of Medical Practice has jurisdiction over me insofar as how I practice medicine, my professional conduct. But they don't have jurisdiction over my speech that is apart from professional conduct. In other words, I get to talk about issues of the day, whether it's Ukraine, our southern border, our economy, whether or not masks work to stop viral illnesses, what we should be doing with our kids in regards to education and absenteeism from school. I get to talk about those things as a citizen. So that's the situation there. We want the courts to help draw that line so the Minnesota Board of Medical Practice doesn't step over it, because we think they did. We think the Board of Medical Practice was literally allowing themselves to be weaponized by going after me with 20 different allegations, 6 different investigations. So where's that court case? We've been in court. We've exchanged documents. We've gone through a lot of the legal stuff that I won't go into detail. But where we're at is the Attorney General's office, which is representing the Minnesota Board of Medical Practice, filed a motion to dismiss the case because of several reasons. We opposed that. We had our day in court. Judge Jerry Blackwell ruled that he was ruling in favor of the Attorney General's motion to dismiss. because I lacked standing. If you don't have standing, you can't sue someone. From a non-lawyer's perspective, when I read about standing, and I've done quite a bit of reading about it because I got this book called The Constitution of the United States, and I'm trying to educate myself. But I need to demonstrate that I was harmed, that it was the Minnesota Board of Medical Practice that harmed me, and that if I get a favorable ruling from the court, that the situation would be remedied. So I thought that all three of those things happened. I mean, I think when the incumbent governor of Minnesota is able to, during a campaign against me, while we're both vying for governor of Minnesota, when he can tweet about my moral character as a potential governor candidate based on a pending investigation from the Minnesota Board of Medical Practice, which ultimately was thrown out, I think that was harm. I think that played a role in our campaign. So I think I was harmed. I think the Minnesota Board of Medical Practice was responsible because, in a sense, they were inadvertently weaponized. And I think that if the courts would rule in my favor, they could fix that. Now, having said that, I want to say this. The Minnesota Board of Medical Practice is composed of a lot of really good people who are trying to do good things, and this is not a paid position. This is a voluntary position. In all of my dealings with the support staff, the attorneys, the members of the board itself, I've been impressed with their character without question. I have no desire to hurt their feelings or make their lives miserable. I'm not suing for a big chunk of money. Frankly, I would love to see the Minnesota Board of Medical Practice come out and say, listen, perhaps we have erred. Perhaps we crossed a line that isn't clearly defined, and the courts could help us there. Perhaps the legislature could help us by drawing up statute that would provide us the discretion to throw out some of these spurious complaints. I would like to see the Minnesota Board of Medical Practice less politicized. I'd like to see staggered terms with appointments not necessarily coming just from the governor's office. I don't know that it's a good idea to have the Minnesota Board of Medical Practice be a political body potentially appointed completely by a partisan governor. And I think all governors are partisan. So these are some things that I want you to know, that the human side of suing the Minnesota Board of Medical Practice is not about demonizing anyone. These folks are trying hard to make good decisions. So having said that, the judge ruled in the favor of the Minnesota Board of Medical Practice to dismiss. We noticed that the judge also said that he was inviting us, that if we wanted to, we could within 21 days submit an amended complaint, because we could argue then more on the grounds of standing. So that's what we did. Dozens and dozens and dozens of pages were submitted. After we did that, the Minnesota Board of Medical Practice Council, the Attorney General's office, once again, after reviewing our amendment, our amended complaint, they submitted a request for dismissal. We responded to that. And in August, that's what we'll talk about in front of the judge. My attorneys, Greg Joseph, a private attorney, and James Dickey with the Upper Midwest Law Center, have been remarkable people. I am so blessed to have them counseling me and being at my side and representing me. So I've talked about the Minnesota Board of Medical Practice. I've talked about my attorneys. I want to say this about the Attorney General's office. Everybody I have dealt with there has been upstanding, reasonable, and conscientious, and I appreciate that very much. People have asked me, why are you still doing this, Scott? This is bigger than simply a family doctor working in the trenches in Watertown, Minnesota. This is about inadvertent weaponization of government agencies, and it happens. Literally, people with potentially unkind intentions might well decide to utilize regulatory agencies, whether it be licensing or inspection, but some type of government agency. There will be people that might lack kind intentions that want to weaponize these and make someone else's life miserable. And that can be done quite easily. I have learned that. I think the current term these days is lawfare. At every step of the way, use whatever you can to use the legal system to declare war on someone. and I resent it. But those people I can't speak to because I don't get to know who they are. That's the whole thing. This whole process allows the complainants to have anonymity, which seems pretty bizarre, especially when some of these complainants might be repeated complainers that potentially never get to first base with any of their complaints because there's no due diligence or no reasonableness to it. And these are the situations where I want the Board of Medical Practice just to throw them out as being spurious. But the one person I haven't talked about at all in this process is the judge, the Honorable Jerry Blackwell. So I just did a couple of quick searches, and part of the reason I did that was because there was a recent decision a couple of weeks ago, and it was called A Landmark Victory for Physicians and Patients. The Fifth Circuit Court made a decision, and here's what it said. This is an article written by, I think, Marge Johnson, and it was regarding, it's from the AAPS, the Association of American Physicians and Surgeons. So I'm going to read from it. The U.S. Court of Appeals for the Fifth Circuit established the right to object in court to censorship of physicians' speech on topics ranging from government COVID policies to abortion, stated the General Counsel for the AAPS, Andrew Schlafly. I don't know that person. The court held that there's a constitutional right to hear and to challenge censorship. The Association of American Physicians and Surgeons sued 3 medical specialty boards for their threatened actions against the board certifications of physicians because of speaking out on medical controversies. Physicians earned and need these board certifications in order to practice medicine in most hospitals and remain in most insurance networks. This has happened across the nation. Various specialty boards have used their clout to threaten, and I would submit, chill the voices of many physicians simply because they spoke out on medical controversies. The defendants in this case were the Board of Internal Medicine, the Board of Family Medicine, and the Board of Obstetrics and Gynecology, and also the Homeland Security Secretary, Alejandro Mayorkas. And he's a defendant due to alleged government interference with freedom of speech. So, Fifth Circuit Judge James Ho agreed with the panel, the appellate court panel majority, and said, in America, we don't fear disagreement, we embrace it. We persuade, we don't punish. We engage in conversation, not cancellation. And what this allows is the Association of American Physicians and Surgeons can now pursue its claim against censorship by the Biden administration. Judge Ho also said, we know how to disagree with one another without destroying one another, or at least that's how it's supposed to work. With this landmark ruling in favor of the First Amendment, our country can end improper censorship of viewpoints, Andrew Schlafly stated. But I want to go back to what Judge Ho said. We know how to disagree with one another without destroying one another. That's why I want to share a little bit about the human side of filing suit against good people. The Minnesota Board of Medical Practice should not in any way be demonized or destroyed because I'm filing suit against them. I think that there's a problem. I think that my First Amendment rights have been violated. It may well have been inadvertent. It may well have been the Board of Medical Practice reaching out for jurisdiction beyond its guardrails. Regardless, we need to fix it. And that's why we're asking the courts to do so. The bulk of the responsibility to do this falls on Judge Jerry Blackwell. So I looked him up. He's a very talented lawyer. This was an article in MinnPost, December 7th, 2022, about a year and a half ago, by Anna Radalet. Here's what she said. The U.S. Senate late Wednesday voted to confirm Jerry Blackwell, the attorney who is tapped to prosecute the Derek Chauvin case, as Minnesota's newest federal judge. It goes on to say that the bipartisan vote to confirm Blackwell was 51-43, with all Democrats present and 5 Republican senators voting for his confirmation. So all the Democrats voted for him, and 5 of the Republicans voted for him. The great bulk of the Republicans did not vote for him. Here's some quotes from the article. Jerry Blackwell is one of the most widely respected and accomplished members of the Minnesota legal community, said Amy Klobuchar after the confirmation vote. Quote from Keith Ellison, Minnesota Attorney General. Jerry is not one of these lawyers who took a case because he's pugnacious and just wants to fight. He'll treat the litigants well, and he will be an extraordinary judge. Outside the quote, it says, Minnesota Attorney General Keith Ellison, a friend of Blackwell's for decades. It's interesting. The Honorable Judge Blackwell is a beekeeper. Blackwell deviated from his career as litigator of civil cases last year when he agreed to prosecute the Derek Chauvin case for free. It says, Keith Ellison said he eagerly accepted Blackwell's office to help in the case against Chauvin. In the beginning, it wasn't clear what role he was going to play. Nor was it clear what Blackwell, a lawyer who commanded very high fees, would charge the state. Quote from Keith Ellison, I said, what are you going to charge me, Jerry? He said, nothing. That was my favorite price, Ellison said. So Judge Blackwell participated in the Derek Chauvin case on a pro bono basis. About a year to 2 years later, he was nominated by President Joe Biden and confirmed by the U.S. Senate to be a federal U.S. District Court judge for Minnesota. I think it's noteworthy to say that when I saw Judge Blackwell in action the first time I was in court with him, I was very impressed. I was impressed with the pointed, probing nature of his questions to both my attorneys and the Attorney General's attorneys. I find Judge Blackwell to be compelling and logical, and I'm hoping that at some point in time he will acknowledge that I have standing, but that remains to be seen. And I also want to make one last comment that according to the MinnPost article, according to Jerry Blackwell's financial disclosure form, Blackwell made $860,000 in his role as CEO of his law firm in 2021. And he stepped down from that and is now a federal district court judge. And the annual salary in 2022 for federal district court judges is $223,400. So he went from over $800,000 to less than $225,000 in order to serve as a judge in the Minnesota area, and specifically as a federal district court judge. So that's the status right now. The suit against Keith Ellison in the Attorney General's office for not complying with the Data Practices Act is over. I feel good about the fact that Judge Kane compelled him to produce documents he did not want to give me, and I appreciate it. And those documents have played a role in our subsequent shaping of our briefs against the Minnesota Board of Medical Practice. That case is over. Now, before Jerry Blackwell in his court, we will appear in August as scheduled, hopefully, and we will be arguing the situation regarding dismissing the case regarding me having or not having standing. And subsequent to that day in court, somewhere along the line, we'll get another decision from Judge Blackwell. It could be anywhere from a month to 12 months. We don't know that. But obviously that decision will then determine what both sides might consider doing. But I think it's important to say that we have a judicial system that in so many ways in this country and in this state has functioned as a check and balance for the executive branch and the legislative branches of government. And I'm grateful that we have that. I think there's a lot of people who are extremely concerned that every sector of our government has potentially been weaponized in one fashion or another. And I'm here to tell you that a lot of times you can end up being the defendant with a lawsuit against you, and you're a good person. And it's simply that we need some adjudication to try to determine whether or not we could be doing something better, whether or not legislative statutes need to be revised, whether or not a governmental agency needs to be provided with more specific direction and guideline as to where their jurisdiction begins and ends. But I just want you to know, this is where we're at, and I feel like I have filed 2 very appropriate lawsuits, and the people that I've been involved with in regards to these 2 lawsuits, from the judges to the lawyers to the defendants themselves and the defendants' attorneys, have all been honorable, upfront, well-intentioned people, and I appreciate that. I'll try to keep you posted. Thanks a lot, Dr. Scott Jensen. And I just want to say thanks for all the prayers, the support financially, the well-wishing, whether you saw me at the gas station or whether you saw me in church or whether you saw me in the office. I really appreciate it. God bless America.